Hello and welcome to the analysis of the Hindu newspaper dated December 22nd, 2022. In this video, we are going to talk about two important newspaper articles. Now, these articles have been taken from the Hindu newspaper. That is why they are going to be very important, very significant for the civil services examination. So, let's now talk about these particular newspaper articles. So, the first important newspaper article is going to be regarding the Kerala's biodiversity and the forest buffer zone. Now, this particular article is important for the GS paper 3, that is conservation, environmental pollution and degradation, environmental impact assessment, that is GS paper 3. Now, let's understand the context of this particular newspaper article first. Then we are going to talk about the ecologically sensitive zones. We are also going to talk about what were the guidelines issued by the central government as well, right? So now the Kerala Chief Minister Pinarayi Vijayan on Wednesday assured people living on the extremities of protected forest spread across 115 densely populated panchayats. Now these 115 densely populated panchayats are near the forest areas or the protected areas. Now, according to the Supreme Court order of June 3rd, it has been suggested that 1 kilometer buffer zone or minimum of 1 kilometer buffer zone must be around the protected areas. Now that you are making these protected areas, it will come with some of the protections, it will come up with some of the bans which may be imposed on the local communities. And that is what Pinarayi Vijayan is reassuring over here, that these communities are not going to be destroyed, or they are not going to be affected by this particular order. Now, what is this particular order that is so much talked about? Now on June 3rd, there was an order passed by a 3-judge bench which said that national parks, wildlife sanctuaries and such protected areas must have an eco-sensitive zones of minimum 1 kilometer from their boundaries. Now these eco-sensitive zones will come with some of the bans and some of the regulations. Now the Supreme Court said that guidelines issued by the MOEFCC, that is Ministry of Environment, Forest and Climate Change, on all the guidelines which are issued on 9th February 2011 will have either banned or regulated a bunch of activities within the ESZs should be strictly adhered to. Now the proceedings which led to this particular Supreme Court order originated from 1995 PL. So there was a PIL which was filed by T.N. Godavarman Thirumul Pad, who was a native of Nilambur in Kerala's Malappuram, and he sought protection of forest lands in the Nilgiris district of the Tamil Nadu. Now this particular order is applicable to the entire country, but it affects the Kerala such that the Kerala has the highest amount of forest cover. It has the highest number, it has a very large number of protected areas, it has a very large number of national parks, wildlife sanctuaries and the bird sanctuaries, right? And that is why it affects the Kerala very largely, because all these 115 densely populated panchayats are near the protected areas, and they fall under the ecologically sensitive localities. Now this poses a problems to the locals. Now what are the ESZs or the ecologically sensitive zones? So basically the National Wildlife Action Plan of 2002 to 2016 of the MOEFCC stipulated that state governments should declare land falling within 10 kilometers of the boundaries of national parks and wildlife sanctuaries as eco-fragile zones or ESZs under the Environmental Protection Act 1986. Now it has been reduced to 1 kilometer, minimum of 1 kilometer, and the maximum it depends upon the state government, right? But basically the minimum of 1 kilometer needs to be made as eco-sensitive zones according to the Supreme Court order. Now while 10 kilometer rule is implemented as a general principle, the extent of its application can vary. Areas beyond 10 kilometers can be also be notified by the union government. Now this has changed to 1 kilometer, right, according to the Supreme Court order of June 3rd. And what was the aim of this particular National Wildlife Action Plan? So it was basically to regulate certain activities around national parks and wildlife sanctuaries so as to minimize the negative impacts of such activities on the fragile ecosystem encompassing the protected areas all the activities, all the human activities that lead to fragility in the ecosystem, it is going to be protected, right? All the fragilities are going to be looked into, and that is why the regulation of the activities becomes very, very, very important. Now the 2011 guidelines basically issued some of the bans and some of the regulations regarding the ESZs, that is the ecologically sensitive zones. So you could basically so the banned activities in the ESZ include mining, running of sawmills, polluting industries, commercial use of firewoods, mega hydel power projects, manufacturing of hazardous objects, and mining would be only allowed for the local use. So these are some of the banned activities. Now there are some of the regulated or restricted activities. Though there is some kind of ban, but some kind of regulation or some kind of freeness is also given. So the first one is the felling of the trees, and it is only permissible from the authorities. Only if you get the permission from the authorities, you are allowed to fell the trees. And the second is establishment of hotels and resorts as per approved master plan, because Kerala has many of the ecotourism opportunities. That is why the hotels and resorts, now that hotels and resorts are going to be regulated, and that is why it proves to be detrimental to Kerala, because it depends largely on its natural resources in order to boost the tourism. Now it also has drastic change in the agriculture. Now drastic changes in the agricultural sector systems in the eco-sensitive zones is not allowed. Commercial use of natural water resources including groundwater harvesting is not allowed. Now erection of the electrical cables with stresses on the underground cabling is restricted, and fencing of the building premises, widening of the roads, ban is on the vehicular traffic at night. So these are some of the restricted activities. Now we have some of the permissible activities which are permitted. For example, the ongoing agriculture and horticulture practices are allowed. Now rainwater harvesting is allowed, organic farming is allowed, adoption of green technologies for all activities is also allowed. So these are some of the guidelines of the 2011 which are going to be adhered according to the Supreme Court order of June 3rd. Now what is the significance of the ESZs or these buffer zones? So it minimizes the impact of development activities, and the second is in situ conservation, that is on the site conservation is possible. And the third one is that it minimizes forest depletion and man-animal conflict. Man-animal conflict happens when the human activities are increased near the protected areas or the forest areas, right? So these are going to be reduced because the protected areas are based on the core and buffer model of management, through which local area communities are also protected and benefited. Now the fourth significance is that it minimizes the negative impact on the fragile ecosystems. Now it acts, this buffer zone or the ESZs acts as a shock absorber for the protected areas. The protected areas are not intermixed with the human civilizations if you create the eco-sensitive zones. Now it also acts as a transition zone from the areas of high protection to the areas involving lesser protection. So this is the significance of the ESZs. Now let's talk about the challenges which are posed to the eco-sensitive zones. So the first one is the development activities. So basically the activities such as construction of dams, roads, urban and rural infrastructure in the ESZs create interference, negatively impact upon the environment and imbalance the ecological systems. Any development in and around the eco-sensitive zones is going to affect the eco-sensitive zones, and that is why it can have effect the development effect, and development activities can affect the environment in the long run, right? And the second one is the governance and the new laws. So by failing to recognize the rights of the forest communities and curbing poaching of the animals, legislations like the Environmental Protection Act 1986 and Wildlife Protection Act 1972 undermine the ESZs in favor of developmental activities. All the developmental activities happen in these eco-sensitive zones. For example, like the tourism happens in the ecologically sensitive zones, but it undermines the rights of the local communities. Now the lands around parks and the sanctuaries is being cleared through deforestation, displacement of local people, etc., to cater for tourism. Now tourists leave behind a lot of garbage like the plastic bottles or the plastic bags. Now it also leads to the environmental degradation of the eco-sensitive zones. Now these are some of the eco-sensitive zones, challenges to the eco-sensitive zones. But let's now talk about the Kerala. Now Kerala is a very highly dense, has a very high dense forest cover, right? Now Kerala's forest cover as per the data available from 2019 to 2020 is basically 11,521 square kilometer, which forms 29.65% of the state's geographical area, which is very high. And this ratio of forest to total geographical area is much higher than the national average of 6.09%. And the state's forest cover has been going up with the increase of 823 square kilometer from 2017, which means that the local communities are very sensitive towards all of the forest covers. They want the forest cover to increase. They want their forest to be very healthy. Now this particular thing can be utilized, or it can be this local community link with the forest can be utilized in a very positive direction. Instead of creating the ESZs, we can promote all of these areas into the tourism or whatever the areas are around it, and we can create a link between the forest and the people, so that the forests are protected in the long term. Now Kerala has basically 23 protected forest areas, of which 12 are wildlife sanctuaries, and the 3 are bird sanctuaries, 5 are national parks, and 2 are the tiger reserves. All right. And if you look at the map of the Kerala, these are, though this map is not very accurate, but it gives you a picture of how many protected areas in Kerala. Basically, the entire map of Kerala covers all the protected areas, right? So this means that these protected areas needs to be protected at all cost, but it should not come at the cost of the local communities. This is what is the essence of this particular newspaper article. Let's now talk about the next important newspaper article. Now this particular newspaper article talks about a clash between the Aam Aadmi Party, that is the ruling government of the Delhi, and Delhi's LG, who happens to be the lieutenant governor, right? So this particular article talks about the fact that Delhi's Lieutenant Governor Vinay Kumar Saxena has directed Chief Secretary Naresh Kumar to implement a 2016 order of the Committee on Content Regulation in Government Advertising. Now this CCRGA was implemented an order, right? It gave an order. Now this order was not adhered to according to the LG, and now it should be adhered to by the ruling government. Now the order calls for recovering 97.14 crore plus interest from the ruling Aam Aadmi Party for political advertisements published or telecast as government advertisements in 2015 and 2016. So this was the amount that was spent by the Aam Aadmi Party in 2015-2016. Now this CCRGA said that all of this amount should be recovered from the Aam Aadmi Party, right? So let's talk about this particular newspaper article in detail. So what basically is this CCRGA? So basically it is a 3-member body. Now this particular CCRGA was formed by Union Ministry of Information and Broadcasting in April 2016, and it was basically formed on the directions from the Supreme Court order in its judgment in the Common Cause versus Union of India case in May 2015. So what is the chronology? First, a Supreme Court judgment was passed on May 2015. Now name of the judgment was Common Cause versus Union of India. Now this particular judgment led to the formation of CCRGA in April 2016 by Union Ministry of Information and Broadcasting. Now let's talk about this particular body, which is CCRGA. So basically the body is set up to regulate the content of central and state government advertisements in all media platforms, right? Now the Supreme Court has also mandated the states to constitute their own respective bodies, and the states who do not form their own respective bodies regarding the content regulation are going to come under the monitoring of CCRGA. Alright. So now the Supreme Court in its order has also issued a set of guidelines for public funded advertisements by the governments. Now these guidelines include government advertising should maintain, they include the fact that government advertising should maintain political neutrality. They need to provide all the information of the schemes, but at the same time they need to have political neutrality. And the second one is they must avoid glorification of political personalities or projecting a positive impression of party in power, and they must not give a negative impression of parties critical of the government. So these are some of the basically the guidelines of the CCRGA. Now what happened is that there was an interesting thing happening around Delhi, right? In Delhi. Now, months after the formation of CCRGA, a complaint from the Congress leader Ajay Makan or Ajay Makan, whatever it is. Now, he issued notices to the Delhi government. Now, he alleged that they are violating Supreme Court mandated guidelines in publishing advertisements. Now, in its response, the Delhi government informed the CCRGA that it was going to form a committee. Now the Delhi government thought that they are not going to come under the CCRGA, they are going to form their own committee according to the 2015 order of the Supreme Court, which is Common Cause versus Union of India. Now it mandated the states that the states have to set up their own respective bodies to regulate the government advertisements content. Now basically the Delhi is not a state, it is what? It is a union territory. So the Supreme Court, so the Delhi High Court, Ajay Makan has also approached the High Court at the same time. So the Delhi High Court on August 2016 said that union territories are not authorized to constitute their own committees and will therefore come under the jurisdiction of the CCRGA. Now that Delhi High Court had said that they will come under the CCRGA, or union territories will come under the CCRGA. Now the Delhi government had to follow all of the guidelines which have been issued by the CCRGA. So CCRGA issued an order, right? So it conducted an investigation and it passed an order on September 16, 2016. Now it ruled that a number of Delhi government advertisements had violated the guidelines on various fronts. Now these various fronts include publishing false, misleading ads, they were mentioning the party in power by the name, and there was also self-glorification and targeting political opponents, which is basically against the guidelines of the CCRGA, which basically talks about all of these things which we have talked about, right? So now the committee also directed the Delhi government's Directorate of Information and Publicity, which issues government campaigns, to identify specific advertisements, quantify the money spent on them, and recover it from the Aam Aadmi Party. So what were the directions given to the Delhi government's DIP? First, it is to issue the government campaigns to identify all the government campaigns to identify specific advertisements. Advertisements were to be identified, and the second, it needs to quantify the money spent on them, and it needs to be recovered from the Aam Aadmi Party. So this thing was basically not done. Now the amount which was quantified was 97 crores 14 lakhs 69,137. Now this particular advertisement cost was to be paid to the state's exchequer. Out of it, 42 lakh was to be paid to the state exchequer, and the other remaining amount was to be directly paid to the agencies and publications which ran the advertisements within 30 days, and it was to be adhered within 30 days. And this is basically the amount that Lieutenant Governor is talking about, that the Delhi government has not given this particular amount. This is the tussle happening on between Aam Aadmi Party and the Lieutenant Governor, right? So let's now talk about the other side of the story. Now the Aam Aadmi Party says that since forming the government in 2015, it has been defending its spending on advertisements, stating that it is for public knowledge of different government schemes and various awareness campaigns. So this is basically the side of the other party. Alright, so we are not saying who's right, who's wrong. We are just talking about the facts regarding it. We have talked about this particular newspaper article in very detail. Alright, so this is it regarding this particular newspaper article, and this is it for the day. Thank you from my side. Do like and share the video and subscribe to this channel. Have a good day. Bye.